The year is 1972. Richard Nixon is president. The Bruins just won the Stanley Cup. Gas costs 36 cents per gallon, $1.59 in 2015 dollars, and the Sierra Club is suing the U.S. Secretary of the Interior in front of the Supreme Court. Rogers Morton thinks Disney should build a $35 million ski resort in Sequoia National Park. The Sierra Club disagrees. How does a court case for the environment usually work? In their suit against the Department of the Interior, the Sierra Club wanted to use Article 10 of the Administrative Procedures Act. To sue a government agency with the APA, a plaintiff needs to prove that the agency's actions harm them. The Sierra Club encourages many people to join so they can claim that Sierra Club members are being harmed by destruction of the environment. However, in this case, the Sierra Club did not allege that its members were being harmed. They didn't think that they could prove it because no one lives in Sequoia National Park. Instead, they said that the DOI letting Disney build the resort would cause irreparable harm to public interest, and the Sierra Club lost the case. The majority ruled that the Sierra Club would suffer no irreparable injury and therefore had no standing to sue. The Sierra Club has lost a lot of cases, but what if there was an easier way to protect the environment? What if the Sierra Club did not have to prove that human constituents were being harmed in order to have standing? What if nature had standing? Christopher Stone, a law professor at USC, thought exactly that. He saw the Sierra Club case and wrote "Should Trees Have Standing?", a paper arguing for giving nature legal rights.
But at least it should be heard. And if the problem of its being heard is that this club was not injured, suffered no injury, why not just say, look, the injury is suffered by Mineral King Valley?
The Sierra Club lost Sierra Club v. Morton, but the most memorable thing to come out of the case was a dissenting opinion of Justice William O. Douglas. Douglas read Stone's paper and stated that he believed nature should have standing. Douglas agreed with Stone that ships, corporations, and babies all have rights in court, yet cannot represent themselves. So why not add nature to that list? Since the 1970s, the rights of nature in the U.S. have come a long way, and they might expand in the near future. There is some precedent in the United States common law and in the laws of foreign countries for giving nature standing. Of course, foreign laws have no bearings in the U.S., but they provide an example for what could be. Arguments for giving trees standing are: 1. If nature can sue, people will think twice about harming nature. This will help conservation. 2. It would often be easier to name river as the plaintiff than to prove humans are being harmed. And 3. Many things that cannot speak for themselves already have rights, like babies and ships. Arguments against giving nature standing include: 1. Courts have been skeptical about giving animals standing. In the case of Jones v. Butts, a precedent was set that animals could be represented by humans acting as a plaintiff, but could not represent themselves. Nature is even less closely related to humans than animals are, biologically speaking, so courts might struggle even more with giving nature standing. 2. Some believe that ideas like this undermine legitimate conservationists. For conservationists, nature having standing in court would be a double-edged sword. On one hand, the law aims to protect nature, but it would also mean that mankind's management of nature, something traditionally done by conservationists, would be interfered with. 3. A river cannot sue someone because it cannot speak for itself. Someone has to decide for a river that it wants to sue. So does the idea of giving a river standing really make sense? 4. If the language in the law is too vague, companies could abuse it. For example, an oil company could use the law to argue that a massive hydrocarbon deposit has rights and should not be mined. This would prevent competitor oil companies from mining that massive hydrocarbon reserve and allow the first oil company to artificially drive up prices and unfairly hurt competition using the law.
There has already been implementation of the idea of natural entities having rights in countries like Ecuador, New Zealand, and India. In Ecuador, changes were made to the constitution so that the rights of nature would be recognized, making Ecuador the first country to declare the rights of nature in its constitution. The Vilcabamba River successfully won a case against the government of Loja in 2011 following the amendments made to the Constitution. On March 30, 2011, Wheeler and Huddle brought a constitutional injunction to the Provincial Justice Court of Loja on behalf of the river against the provincial government of Loja. By suing on behalf of the river, Wheeler and Huddle were able to ensure that any reparations made went towards repairing the damaged river as opposed to going to the people. Although these constitutional changes were revolutionary, there are still obstacles present. In Ecuador, there has been limited success in the implementation of the constitutional rights of nature because the economy is dependent on the environmental damage that these rights seek to address. This is evident when looking at Ecuador's search for oil. President Rafael Correa made the decision to end the environmentally aware Yasuni ITT initiative. This initiative proposed the protection of the diversity of the Ishpingo Tambucha Tiputini section of the Yasuni National Park through a ban on oil drilling. However, due to the lack of financial support from the UN, the initiative failed, showing how tied Ecuador's economy is to oil. Here in the U.S., we have started seeing the implementation of rights of nature at the municipal level. In 2006, Tamaqua Borough, Pennsylvania became the first U.S. community to grant the rights of nature. This created precedents for other communities to follow suit, leading to dozens of cities across America to adopt this ordinance. In Tamaqua Borough, this ordinance was created in response to waste corporations dumping toxic sludge in the community. With assistance from the Community Environmental Legal Defense Fund, also known as CELDF, the community of Tamaqua Borough was able to ban sludging as a violation of the rights of nature law, making this community the first in the nation and the world to recognize the rights of nature in its law. This ordinance states that it shall be unlawful for any corporation or its directors, officers, owners, or managers to interfere with the existence and flourishing of natural communities or ecosystems, or to cause damage to those natural communities and ecosystems. However, challenges have arisen when it comes to the enforcement of this ordinance. In November 2010, Pittsburgh, Pennsylvania became the first major city in the United States to adopt this ordinance that enforces the rights of nature. The community wanted to ban hydrofracking within city limits and believed that by declaring rights to clean air, water, and soil for their citizens, and through a rights of nature strategy, they would be able to do this. The Pittsburgh City Council unanimously passed this measure to ban hydrofracking within its city limits. Although this is a breakthrough in the advocacy and rights of nature, this is still only on a local level and could be metamorphic on a larger scale. If the idea of nature having rights were to be adopted at the national level, it would transform environmental law and change the way we think about the environment as a whole. On September 25, 2017, in Denver, Colorado, Jason Flores, a Denver defense attorney, along with the Deep Green Resistance Group, filed a lawsuit against the state of Colorado and Governor John Hickenlooper. This lawsuit was filed on behalf of the Colorado River due to mismanagement of the river. If a federal district court finds fault to be on behalf of the Colorado government, then this could set precedents for other natural entities to be granted personhood under common law. If precedence is established, accountability can be placed on the polluter, corporations, and the government. The burden of proof would no longer fall onto the advocates of activists of nature and the environment.